afternoon. We'll get started in 1 minute. Good afternoon. My name is Maya Wiley. I am the President and CEO of the Leadership Conference on Civil and Human Rights. We are the nation's oldest and largest civil rights coalition, more than 200 national organizations strong, and we look like this nation. We are the people of this nation, and we are here today to discuss the Supreme Court's decision on affirmative action. With us are the incredible leaders who are both member organizations and critical civil rights litigators. Damon Hewitt, President and Executive Director of the Lawyers Committee for Civil Rights Under Law. Janae Nelson, the President and Director Counsel of the Legal Defense Fund. Marita Etubanez, Vice President, Strategic Initiatives at Asian Americans Advancing Justice. Lourdes Rosado, President and General Counsel of Latino Justice, and David Hinojosa, who is at the Lawyers Committee as well, Director of the Educational Opportunities Project, who argued before the Supreme Court. You will hear from all of these important leaders, but we start by saying we stand together as a civil rights community. We stand together as community leaders representing community who have fought for the recognition that today's America has still not lived up to the ideals we deeply share as Americans. An ideal that says we must have opportunity to learn, freedom to learn our history, freedom to read books by Pulitzer Prize-winning authors, even when they challenge and make some people uncomfortable. That we are in a country today where we are still struggling to have a fair right to vote. And when we talk about educational opportunity, when we talk about whether and how we create more opportunities for every single American without regard to where they live, without regard to how many resources they have, and without regard to the color of their skin, and our long-standing history of throwing up barriers in the face of too many of our communities because of how we look, because of our languages, our nations of origin, despite our contributions. That this is the time when we say President Joe Biden is right. He is right to say that this is not a normal court. He is right to say that we have ideals that we have not lived up to, and he is absolutely right to say that we can and we must continue to ensure that every single one of our children has the opportunity to get the education they deserve and, quite frankly, they have earned. And President Biden, in his press conference that we all watched together, demonstrated a knowledge and understanding of the admissions processes of both Harvard and the University of North Carolina that far outstrips the description that we saw and the understanding that the Supreme Court shared in its majority opinion. And that Ketanji Brown Jackson in her dissent is absolutely right. We are a society that wants a country where what we look like does not impede our opportunity. And we do not yet live in it. And that is why we are going to continue to fight together and unify and not let those who try to pit our communities against one another to succeed. With that, I want to ask Damon Hewitt to speak.
Thank you, Maya and colleagues. This is a challenging day for not just students, a challenging day for not just advocates, but a challenging day for this nation. Today, the United States Supreme Court got it wrong. You know, my organization, the Lawyers Committee for Civil Rights, was founded by President Kennedy in 1963, a pivotal summer for the civil rights movement. This organization was founded when a racially integrated group of lawyers came together to put some skin in the game to advance civil rights. We've been doing that for 60 years. Under rulings like today's, it's not even clear how our organization could have been founded or flourished over those years, all of this time. Now, through a tortured interpretation, this court decided not to fully overrule precedent, and it certainly did not affirm clearly longstanding precedent as fully as it should have. It did something in the middle. Through a tortured interpretation of law, of history, of present-day fact, the court has taken the law and our society and put us in a pretzel. One must engage in mental gymnastics to even understand the logic or purpose of today's decision, to understand what are universities and colleges supposed to do with this ruling, which puts into some confusion, at least for them, what they're supposed to do given what they've been doing for nearly 45 years, and in many cases long before. That is a decision, this is a decision rather, that is not just confounding on the law, but is also morally bankrupt and intellectually dishonest. Now, let's be clear about how we got to this point. For decades upon decades, in fact, ever since affirmative action existed in any context, opponents have been trying their best to end it. And almost every time they've lost, especially when they go up to the U.S. Supreme Court, they continue to lose. But when you make up a fake organization, when you spread false narratives about a dichotomy between diversity and merit, when you tell specific students, hey, you're being hurt, when they don't even think they're being harmed, that's how you get to this point. And when you have a supermajority, some of whom in this court are more than willing to take up this rabid pursuit of a race-blind society that does not match the lived experience of students, of higher ed professionals, it doesn't even match the lived experience of many jurists on this court and in federal courts. That's how we get to this point. Now, where do we go from here? This court is clearly on the wrong side of history. There's no doubt about that, but we cannot rest. As President Biden said, this court cannot and will not have the last word. Now, let's be clear. This decision is not a good one, but it could have been even worse. At the very least, this court has rejected the full-throated race blindness approach. Even this court has cognized that colleges and universities may still ask students about what we call their racialized experience, or put a different way, ask students about their identity, their full path, the full arc of all that they bring to the table, their whole selves. And you know what we're going to do? We will continue to encourage students to do the same. We will force the issue, because no matter what this ruling says, we have to be clear that affirmative action is a tool, but the prize is racial equity, racial justice, and opportunity for all, especially those who have been historically marginalized. No matter what this court says, we will continue to fight. No matter what this court says, nothing can deprive us of what we call our race-conscious future, the future that we deserve, the future that students deserve. Because affirmative action and holistic admissions is not a handout. It's not even really a hand up. It is what students deserve when they bring their whole selves to the table. We also have to be clear about what this case is not about and what the holding is not about. There are a lot of folks out there predicting and saying the sky is falling and now no school can engage in any type of race-conscious admissions at all. They're saying that businesses can't pursue diversity, equity, and inclusion programs. We have to dispel all of those myths. We understand the concern and the fear. And we in the civil rights community are here to help. We're here to give that critical advice. But what's important is that this is not a moment for retreat. You know, we're under attack from all sides. You know, the opponents that we're facing are not just anti-woke, they're anti-vote, they're anti-opportunity, they are counter-majoritarian. They're against what this country stands for. So this is a time when we need a whole-of-society approach. I was so heartened to hear President Biden speak in clear and unambiguous terms about continuing to fight. Like him, we call upon higher education to revisit its own standards and look inwardly, because race-conscious admissions does some of the work, but not all of the work. It's a critical tool, but we need universities to address legacy admissions, to address over-reliance on standardized tests that underpredict systematically talent among black and brown students. In our view, that is the civil rights violation. We will not rest for that. We want our students to continue to lift up and be their whole beautiful selves, and we need higher ed to say that you are embraced and you are welcome here. We need businesses to do the same. Every entity that had some profound statement after George Floyd was murdered that created a new initiative that included grant making or internal work. Keep doing that work. Don't backslide. Now is not the time for retreat. Again, nothing can deprive us of our race-conscious future. Nothing can deprive black and brown students and all students of the future they deserve. Thank you. I'll now invite up Janae Nelson, my good friend, President and Director Counsel of the Legal Defense Fund.
Thank you, Damon. Good afternoon, everyone. President Biden said that diversity is our nation's greatest strength. That was as true before the decision as it is after the decision. What happened today is that the court made it more difficult for us to tap into, leverage that strength to make us safer, to make us stronger, to make us become a more perfect union. The court did that. The court undermined that ability. A court that has, for over 45 years, affirmed affirmative action, has said that it is lawful, that it is consonant with the Equal Protection Clause. The only thing that has changed in those 45 years is the composition of that court. It is now a conservative majority that dictates the policy making that is coming out of that court. And today's decision in the University of North Carolina and Harvard admissions policies is a demonstration of how far afield the court has gone. As my colleagues have said, we will not let this be the last word, and it is so important that we recommit to the work of diversity, equity, and inclusion. In fact, today's decision makes that moral imperative that much more critical in this moment. All of our students, all of the people who occupy the next generation in this country, who will be our next leaders, who will be our next voters, deserve to be in classrooms where they see one another, where they learn from one another, where they develop understanding and respect for one another and for differing viewpoints. That is the strength of diversity. And this court today undermined one of the most important legal decisions that this country has ever known, if not the most important. Brown versus Board of Education, that the Legal Defense Fund had the privilege of litigating and winning in 1954. Justice Sotomayor quoted Thurgood Marshall in her dissent, her powerful dissent in this decision, and said that as the architect of the Brown litigation, Thurgood Marshall was very clear. Brown never meant that we were to be colorblind or that we could not address racial inequality. In fact, to the contrary, Brown was all about recognizing, confronting racial inequality and saying that the government can play a role in addressing it. And institutions can play a role. Universities, schools can play a role. And that's what race-conscious admissions does. It takes qualified students. It allows them to tell their stories. It allows admissions professionals to consider those stories and what enrichment that would bring to the classroom, and admit students to create a vibrant exchange and marketplace of ideas in our institutions of higher education. Unfortunately, the Supreme Court took this opportunity to allow extreme conservative organizations to dictate how it should interpret the Equal Protection Clause and how it should interpret this long-standing precedent that is nearly 70 years old of Brown versus Board of Education. We are alarmed by this decision, but it does not in any way change what we are allowed to do in thinking about how race intersects with one's identity and how it influences one's lived experiences. And I say this directly to the students, I say this directly to the university presidents, directly to the admissions professionals. The court said nothing in today's opinion says that a student or an applicant cannot use race as part of their admissions submission to explain their lived experience. to talk about how it has impacted their lives, the adversity they may have had to overcome, the experiences that they have had in this country that has a very clear history of racial discrimination and current reality of the same. So while we are all disheartened and dismayed by this decision, we are also clear about the mandate that we all have before us. And that is not to abandon the project of diversity, but to double down on it, because that is what our democracy requires. We have an opportunity to make sure that this decision does not undermine the efforts of decades of litigation, of organizing, and frankly, of progress for America. I want to thank the students who we represent, the Legal Defense Fund. We represent organizations in Harvard, 25 organizations that represent thousands of students who are Black, brown, indigenous, Asian, and white students, alumni, faculty who believe in the principle of diversity and who have been with us every step of this fight. It is their future that we're fighting for. It is their future that we will not abandon. It is their future that the court undermined in some ways today, but we will not let that be the last word. Thank you.
Hello, everyone. I am Marita Equibanez, Vice President of Strategic Initiatives with Asian Americans Advancing Justice, AAJC. So we are deeply disappointed that the Supreme Court came down today on the wrong side of protecting educational access and instead opted to resurrect barriers to higher education and support systemic racism. I'm here today representing Asian Americans Advancing Justice, AAJC, to say that we will not stop working to ensure equitable access to educational opportunities for Black, Latino, Native American, and marginalized Asian Americans despite today's ruling. We know that the majority of Asian Americans support affirmative action policies. In fact, 69% of Asian Americans favor affirmative action in education. What this means is that Asian Americans Advancing Justice, AAJC, and the majority of the Asian American community will work with our allies to push educational institutions to create more opportunities for students of color to enter their schools of choice, to not let this ruling be an end to talented students getting into schools like Harvard and UNC, and to ensure that our future leaders of this country represent the multiracial makeup of our society. Our nation's future depends on people across races and ethnicities working together to achieve equity and diversity in higher education, and ultimately a thriving multiracial democracy. Having multiracial diversity helps everyone, including Asian Americans. Diversity brings us new perspectives, new leadership, improved mental health, and economic growth. It is important to remember that talent is everywhere, and it is incumbent upon all of us to ensure that we create real pathways to unlock that talent in every student, no matter what community they come from. Now, I have a specific message for those Asian Americans who joined with SFFA in this court case because you believe that affirmative action discriminates against you and your children. I am now calling you in to our movement to ensure that no student in a community of color is discriminated against or marginalized because of today's ruling. You have an obligation to help create a new and better system than the one you helped to dismantle. We must work to improve our K-12 schools so that all children have the same access to safe and quality education, resources, and learning opportunities, because we know that our public school system is besieged with inequalities. This means that when school boards make efforts to improve access to educational opportunities for Black, brown, and underserved Asian American students, you support, not oppose them. This means we as Asian Americans cannot erase history to fit a contrived, divisive narrative of being the model minority. We cannot ask for our schools to teach Asian American history while suppressing the experiences of Black people. We cannot preach against anti-Asian violence while ignoring the real dangers faced by our LGBTQ and non-binary youth. We will not let Ed Bloom and his anti-civil rights elitist cronies win in the end. We've always known that as we achieve greater levels of diversity and success in this country, there will always be those trying to find ways to undermine or dismantle our achievements to preserve existing power structures. To all college students, those preparing for college and their families, do not be discouraged. We will push all available levers for action and call on Congress, corporate boards, and your own colleges and universities to secure your right to access higher education. Join with us and our amazing student leaders to keep building the movement to expand educational opportunity for everyone. We are here to say to all of those who will try to further undermine our civil rights, you can enjoy today. But in the days to come, our communities will prevail. To our friends in this movement, as we take time to understand the ramifications of this Supreme Court decision, we urge you to not give up. We are not giving up. We will continue the fight with even more energy and even more conviction. So join us in this fight to keep the doors of educational opportunity open for all. Next, I would like to bring up Lourdes Rosado, President and General Counsel of Latino Justice Pro-Bac.
Thank you, Marissa. Good afternoon, everyone. Today's decision goes against 5 decades of precedent, affirming the value of race-conscious admissions and creating pathways of opportunity for millions of families throughout the U.S. It betrays our country's promise of equal access to education and to opportunity. But we're not going to allow the court or anyone else narrow the opportunities or curtail the dreams of our young people. My organization, Latino Justice Pro-Bac, will not back down from our commitment to brace open the doors of opportunities for Latinos and other students of color. For the last 50 years, we, as well as all of the organizations that are represented here, as well as many others who are not here today, we have worked tirelessly to break down barriers and support our youth in gaining access to college and graduate schools, and we are going to continue to do so. We are saying today to our young people, you belong in these elite institutions. You are qualified to be in these institutions. You have earned the right to be there, and we're going to support your success there. Now, we know, all of us know, that elite institutions of higher education are pathways to positions of great power in our country. All you have to do is look at the Supreme Court itself. Throughout its history, the vast majority of justices have attended a handful of the top law schools in this country. Today's decision is not based in fairness, it's not about merit, and it's certainly not about creating a racially just society or upholding equal protection. This decision is just another blatant attempt by those or some with power and privilege in our country to do whatever they can to hold on to that power and privilege. But we cannot allow them to deny our children the same opportunities and pathways to leadership positions in our society that their children have enjoyed, positions that will give our people a bigger say in the future direction of our country and our democracy. We're here to tell those with power and privilege that you have to share. We will not allow you to roll back decades of progress won by hard work and perseverance. Access to education is one of the greatest drivers of success, not just for individuals, but for families and communities. And we also know that investing in more pathways to opportunities leads to true liberty and justice for everyone in our society. Racial diversity in higher education helps set a stronger foundation for a multiracial democracy, a term that my colleague Janae Nelson uses frequently and that I love. And we're going to continue to fight for that goal. We urge universities to invest in the policies and programs that bring a diverse body of students to their campuses and support students so that they can succeed. There is a lot that we can do and that we and universities must do to ensure that our students have access to these opportunities. So we call on everyone today to ensure that those doors stay braced open. And now I'm going to turn it over to my esteemed colleague, David Hinojosa, Director of Education from the Lawyers Committee, who also argued the case before the Supreme Court. David.
Thank you. On October 31st of last year, as I walked into the hallowed chambers of the Supreme Court, we, with the organization, to help bring in the voices of the civil rights community, the voices of students who had participated and had testified in the case about their own experiences with race, about the incredible benefits that they've experienced, and also the incredible challenges that they still faced at the University of North Carolina, and as well as students that we represented in the Harvard case. And the decision that has been reached today, this has been said so many times before, but it is still appropriate today. It is a travesty of justice. We know in the art of law that there is art and there's science to the law. This Supreme Court decision puts a hell of a lot more art into the law. It ignores a well-established precedent. It ignores 40-plus years of experience where universities have tried to administer race consistent with the standards that the Supreme Court has applied. They have gotten rid of quotas. They've gotten rid of separate admission tracks. And they've gone to a system that is incredibly fair and that is not intending to exclude any individual on the basis of race. It provides opportunity for those students who otherwise may be overlooked in a very unfair admissions process because of the gross inequities in our K-12 system that are still carried forward. So what more specifically about this decision is wrong? Janae had mentioned the discussion around Brown v. Board. That is one of the grossest miscarriages of justice by trying to suggest that programs that are intended to bring students together across races and ethnicities, to grow and learn together from one another so that they can share their own perspectives and experiences that inform that of their colleagues and their peers. That's somehow contrary to what Brown v. Board was written for and the problems that it was addressing? Hardly not. And Justice Thomas, who goes even further with his extreme colorblindness interpretation, surprise, surprise, but he was not joined as far. Damon had mentioned, there were many who had argued about this absurd colorblind constitution that apparently existed. And while they did do a gross injustice, to the Equal Protection Clause, which was both an anti-subjugation clause and it was intended to preserve equal opportunity for people who had long not just been treated differently, but had been enslaved and had violence enacted against them merely because of their race. It wasn't individuals who were enacting this. It was America who was involved in those gross injustices. And so we have a decision, again, to be clear, it is not overruling Grutter. It has made it a hell of a lot harder if a university is going to consider race as a plus factor, not just consider racialized experiences. Universities have been and will always be free to consider those. But where those universities want to consider race as a plus factor, it has made it a heck of a lot harder. But it has not totally banned affirmative action. As you all know from last summer, when this court wants to overrule precedent, it knows how to overrule precedent. And that language is not in Chief Justice Roberts' opinion. We know the opposition will continue to push forward its anti-civil rights agenda by suggesting all of these other areas from employment to K-12 admissions programs and the like are all impacted. But that's not true. This decision, this court could have said it, as Justice Thomas alludes to, but again, he stands alone in that opinion. The majority opinion does not quite reach that far, although again, it does do an incredible disservice to the true intent and meaningful intent behind the Equal Protection Clause. The opinion also says in a footnote by Chief Justice Roberts that military academies may too continue to pursue the educational benefits of diversity through diverse admission practices, consistent with its military missions. Those universities, those academies were not before the court, but that is clearly authorized under this court opinion. And then lastly, and this has been alluded to, regarding the racialized experiences. This is Chief Justice Roberts' words, not my words, not the words of Justice Sotomayor. But he says, all parties agree nothing in this opinion should be construed as prohibiting universities from considering an applicant's decision of how race affected his or her life, be it through discrimination, inspiration, or otherwise. I make that point because that is exactly what many of our clients testified to. SFFA did not have any students testify in these cases. That substantial record has 0 student testimony, 0 faculty testimony supporting its position. But yet our clients brave all that you have to when you walk into a federal court to present testimony, knowing that you yourself will be scrutinized, knowing that your testimony will be scrutinized. But they knew it was important to lift up how and why race impacted their decisions, how and why the consideration of their race was so meaningful, and why it meant, or how it showed that they were valued and welcomed at the university. And that should not change. We call upon the universities themselves to continue to engage in substantial outreach in recruitment of underserved students in underserved communities all across the country. They can do that previously, and they should continue to do that. Nothing in this opinion prohibits that. They should also work with communities to ensure their comprehensive policies around recruitment, admissions, climate support, academic supports, counseling, etc., all the way through networking and alumni and job placement. They should work with their communities to ensure all of their practices are aligned with notions of fairness and justice, because that is not prohibited by this opinion. And finally, for those that don't want to visit their own systemic barriers that they've presented, we're putting them on notice. They want to continue those legacy admissions programs that continue to grant privilege, unearned privilege, to people simply because they're an alumni. Let them continue to do it. We're going to challenge them. They want to continue to rely on SAT and ACT scores that have a disparate impact and don't really show much about the value. I might be Exhibit A when it comes to the LSAT. It's a long story. I skipped the question on the test.
We all got this one.
But, the point is that those don't determine someone's value. They don't determine someone's talent. And we're going to challenge them. So they can make it easy and do the changes by themselves, or we can do it the hard way. And we are prepared to do whatever it takes, because history is on our side, justice is on our side, the majority is on our side of ensuring equal educational opportunity for all. And that goes also not just to colleges, but K-12 schools as well. They need to revisit their inequitable funding systems. They need to revisit their disproportionate school discipline policies. They need to revisit their own segregation policies. And if they don't, we'll be there to make sure that they're held accountable under our federal civil rights laws. Thank you.
Okay. We're going to open up to questions. Damon has to run, but David's staying with us. Any questions? Questions? Having none, we thank you for being here. I do want to close on a reminder, just to David's point. 43% of admissions between 2009 and 2014 at Harvard were white students admitted because they were legacy, because of athletics, oftentimes things like fencing and squash that are not available in low-income urban or rural schools dominated by kids of color or low-income kids, or donations. So when we say race blind, what we say is privileging those who are privileged, often because of history as well as because of wealth. And that is why today we're saying this is about all children. Like the President Biden said, and he was so right, from Appalachia to Atlanta. So thank you for being here. Thank you for being in the fight, for all of you who are watching, and we will stay in it with you. Have a good day.